Francisco Ortiz appears on docket 24CR 5534 and is scheduled for a 58A dangerousness hearing on this date.
Good morning,
sir. Good morning, everyone. Are we ready to proceed?
We are, Your Honor. For the record, Courtney Sands on behalf of the Commonwealth.
I'll hear from you.
Your Honor, the Commonwealth is asking the court to consider dangerousness in this matter based upon the packet provided, the reports of the Worcester Police Department, the defendant's history with the Worcester Police Department and the Shrewsbury Police Department in the form of his MasterCard, as well as the reports provided by the Child Protection Program relative to the injuries sustained by 2 of 3 children, and the images associated with those for the court's information. The Commonwealth's request is that the court consider the nature of these charges, which arose from an incident last week. On October 15th at about 4:30 in the afternoon, the Worcester Police Department responded to a 911 call that was placed by this defendant for his child, who was 4 years old at the time and unresponsive. Upon arrival, a detail officer was there quite quickly following that 911 call. That detail officer indicates the child was unresponsive. He initiated CPR. The child was cold to the touch. He made observations as to her person, including that she had just a shirt on, was otherwise naked from the waist down, appeared to have feces covering parts of her body, including her socks and feet, and he saw initially some bleeding from her mouth and from her lips. He described the apartment as being in a bit of disarray. He indicated that there were 2 other children in the home, a 2-year-old boy and a 6-year-old child who was also in that location. Those 2 children were seen medically leaving that scene as well to ensure their overall well-being. The 4-year-old is now deceased. The Commonwealth is awaiting a manner and cause of death determination by the medical examiner. The basis for the request for detention is the assault and battery, which is defined under 209A as Section 1 as a domestic matter. We're asking the court to consider that with regard to this defendant. The child's bruises were significant, and injuries included her left eye, her left and right earlobe, both sides of her neck and chin, her left and right arms, across her upper chest, her abdomen, both hips, her knees, her lower legs, her feet, as well as her neck, and abrasions on her back. It was not until the autopsy had been underway last week that they discovered a significant, what the officers described as significant skull fracture. That's on page 33 moving forward of the police report for the court's reference. The officers described a significant skull fracture that was appreciated by Dr. Scorbella, and that she had advised them that that was a skull fracture on this child that would have taken a significant amount of force. When this defendant was interviewed by law enforcement, he made himself available, he had a conversation. His post-Miranda statements to law enforcement included an indication the child fell, that she had fallen off of a table that was within the home, that she fell onto the ground on her back, and that she received an injury as a result. When speaking with the medical examiner, the detectives learned that that injury that they observed was not consistent with the fall as described by the defendant when speaking with law enforcement. In fact, her body had multiplanar injuries and bruises inconsistent with his explanation. And what they describe is that the force required for that type of skull fracture would not have been associated with a fall of approximately 5 feet from a table in the home, but would have been akin to a fall from a higher level, like a 2-foot level, 2-story level, I apologize, Your Honor, that the child would have had a severe impact to the top of her head. It's described as one where the injuries radiate outward toward her orbital area, and was one that was inconsistent with what they had been previously provided with for information. She had multiple rib fractures that were in various stages of healing, one being an acute fracture on her right side that was in her lower back, her 9th rib, and then healing callus fractures from the 7th and 8th ribs on the opposite side. In essence, the observations were that she had multiple injuries of multiple stages taking place within her body in the process of healing prior to her death. The manner and causes is awaiting the final analysis of her brain, ribs, skull, and some toxicology reports. The Commonwealth provides information relative to the other 2 children and for the purposes of the court assessing this defendant's overall danger. This wasn't an isolated incident involving a singular person, but rather the 2 other children. The 2-year-old had various injuries on his body, which were outlined in the reports, as well as an indication that he now suffers from a skull fracture that they've discovered since his initial treatment. The 6-year-old also has various injuries over the course of her body. She's nonverbal, so she can't tell us what took place within the home. She has difficulty eating because of the level of neglect appreciated by the depositions concerning her mouth, and those images are there for the court's consideration as well, involving her teeth. The understanding is that the children were severely malnourished, and they were severely dehydrated at the time of this intervention by law enforcement and by medical providers. And that particular child, we learned yesterday, which I shared with counsel, has also tested positive for fentanyl. And that's a confirmatory test and not just a test of an initial screening. The children, according to the defendant and according to their mother, is primarily in the care of this defendant. He resides with his mom, has for approximately a year to 2 years, according to him, that he is the sole and exclusive caretaker for the children. His mom acknowledges at times helping to bathe the children within her apartment, within her home, but that this defendant is the person who takes care of them. Mom is in and out of the picture, if you will, visiting at different times sporadically, and what she tells law enforcement is that she had seen one bruise on the child a few weeks prior, like an egg to her head, or a few days prior, I should say, I apologize, but that otherwise had not seen any injuries. She, the defendant, and grandmother all decline or deny that anyone strikes the kids, disciplines the kids, or physically is assaultive of the children. The Commonwealth's request is that the court find this defendant dangerous based upon a whole host of facts that are permissible for Your Honor to consider. The nature and the seriousness of the danger this defendant poses, we would suggest, as evidenced by the injury sustained by all three children. The nature and circumstances of the offense, which, as I described previously, involved a domestic relationship. The penalty that he faces, specifically an assault and battery, serious bodily injury, is one which does not have any district court jurisdiction. It's not more than 15 years in state prison as a penalty for that. All of the other charges are ones which the district court could have jurisdiction over and have a maximum penalty of 2.5 years in the House of Correction. The defendant, as the Commonwealth understands it from his own statements, is unemployed. From his past police reports, it appears as though his prior period of employment was in 2020, and that was a period of employment that ended, it appears as though, as a result of a larceny event that took place at his workplace in Shrewsbury. The defendant acknowledged during the course of his interview that he had a prior substance use issue. He denies using any substances, but in fact, when the warrant was executed within the home and the living space this defendant occupied, was in fact some items which preliminarily appear to be substances. You have a 6-year-old who never leaves the home, according to all the parties, who's not in school, and who tested positive for fentanyl. So certainly has exposure from somewhere. It would appear to be from this defendant as well. There was also a handgun located within that home. The Commonwealth requests that the court make those findings that there are no conditions of release that would meaningfully assure the safety of these particular children, one of whom is deceased, as well as the community at large. The defendant has a history with the Worcester Police Department stemming as far back as March of 2006, up to including this particular event in 2024. Most of it appears to be as a young man. Reading between the lines, my suggestion or my guess is it appears to be a lot of violence relative to gang involvement. It appears to be some issues surrounding him being present when shots are fired, him being present or charged with, if you look at his record, assaults or possession of dangerous weapons, including knives, and him being a disorderly person, being involved with persons who are engaging in violent acts with others. At different points, he was trespassed from Plumley Village, and that's what some of those reports reflect as well. I did also include for the court's information a report where the defendant himself was a victim of a stabbing, because one of the comments made by one of the witnesses that the defendant has a lot of anxiety issues, won't leave the home as a result of this past event that took place. So I wanted the court to have that sort of full picture and have that information as well. With all of those things in mind, the Commonwealth suggests that we've met the requisite standard of clear and convincing evidence and ask that you find the defendant dangerous.
Thank you. Counsel.
Your Honor, my client is 34 years old. He was born in Worcester County, raised in Worcester County. He's been in Worcester County his entire life. This is, albeit a tragic case, but it is at this point a child abuse case. The only true victims that present a risk to the defendant being released are the children who are now in custody of the Commonwealth. My client called for authorities, he called for help, and they responded, and he was cooperative, he spoke with the police, he was forthcoming about the facts and circumstances of what went on. This is not an appropriate case for a dangerousness finding to enter. Rather, it's a case that the court should set a modest cash bail on the defendant. My sister speaks at length about what in fact are medical opinions about what happened in this case. At this point, we're still waiting for those medical opinions. Essentially, my sister is a lawyer. She is not competent to set forth those opinions, and there are multiple layers of hearsay to medical opinions. So, Your Honor, I don't think you should consider them at this time. Thank you.
Thank you. After hearing, I do find that he's a danger. Anyone hold him. There's a motion that was filed to copy and inspect.
A search warrant, yes, Your Honor. So the search warrant for the residence, it was issued and returned yesterday. It issued from the Superior Court, and there was an order of impoundment relative to that search warrant. When it was transferred to the District Court for purposes of docketing, they indicated the impoundment order was for only 10 days. There had been no time specified by the Superior Court. So I'm making two requests. One, pursuant to the other court's order that the parties be allowed to access and copy that, but also that the impoundment exceed the 10 days, which was set by the District Court here and was here and downstairs, and that it, I would suggest whatever time frame the court deems appropriate, but potentially pending indictment in the Superior Court, indictment and arraignment in the Superior Court.
Do you wish to be heard, counsel?
No, Your Honor. There's no objection to that as long as both parties have access.
So the motion's allowed, and it will be impounded until the indictment.
That would be great. Thank you very much, Your Honor.
Thank you.
The only other issue has to do with the exhibits that the Commonwealth provided for the court's consideration today. Due to the sensitive nature of what is contained therein, counsel and I had discussed the potential of impounding those reports. I don't know that there's an objection, or if the court wishes for me to file a written motion to that effect, whatever counsel wishes to do.
No objection to the
Okay. I think for the record, I'd like a written motion. Counsel, you don't have to stick around for it. I'm going to allow the motion once it's filed.
Okay.
So if you could just file that with the clerk, I'll allow it administratively.
Thank you very much, Your Honor.
We just need to pick a date.
We talked about November 20th, if we could please, for probable cause.
That's a good date.
November 20th for probable cause.
So
Thank you.
November 20th will be a video conference, probable cause in courtroom 23. Sir, you've been found dangerous. You're ordered held for a period of 120 days. You have the right to a bail review in the Superior Court, and your 120-day date will be February 12th of 2025. You will be brought in person to courtroom 15 on that day.
Thank you.
At this time, he's in custody.
Thank you very much.